Being a critical factor of production, land has become the go-to investment tool, promising higher returns. But cases of buyers being swindled have also been on the rise. Others have unknowingly been entangled in legal battles after land deals go sour.
Even I've seen a case like in the river where somebody bought land, and then when they went to check on it, they found it was not that. That was a shanty. The real plot was elsewhere. The real plot was in a shanty. Actually, that one I was involved. And then the right one where he wanted to be, it was elsewhere.
So how does one avoid falling prey to fraudsters when buying land? Scholar Kayogira, an advocate of the High Court, advises that conducting due diligence before committing one's finances is a rule of thumb.
And this is because land is not something that you buy for 5 shillings or 20 shillings. It is quite a commitment financially. So you would want to know that whatever investment that you're getting into is a legitimate investment, that you'll get value out of it.
After identifying and getting interested in a piece of land, always start by asking for a title deed to prove ownership. This is often attached to an agent appointment letter should a land agent be the one selling the land. One should then conduct a land search based on the details on the land title. A land search costs 500 shillings and may take up to a week.
Assuming you've been told come back after 3 days, you go collect the results of the search. It will be the same form, but on the flip side is where they will fill the details of the registered owner, whether there are any cautions on the property, whether there is any charge or mortgage on the property. Then it has to be sealed by the land registrar.
It's here that you may wish to rope in a land surveyor to ascertain the land's ground position and acreage. As you do this, a sale agreement ought to be in preparation. This agreement should entail the terms of transaction, including deposit amount, payment period, and conditions for terminating the sale.
So you also need to have a proper agreement for sale in place that takes care of all eventualities, including the event where the seller is unable to transfer the property or the purchaser is unable to, pay the balance of the purchase price.
Lawyers are best placed to draft such kind of agreements.
It is recommended that the purchaser has their own advocate, and so does the seller. And in that situation, again, every party should be able to bear the costs of their own advocate.
Is it quite expensive to have a lawyer on board?
They're not too expensive. It's more expensive to be wrong.
The fee for between, I believe, 0 to 5 million is a percentage, 1.5%.
A well-executed sale agreement often leads to a transfer of property to the purchaser once valuation is done and stamp duty paid. Experts advise that payable amounts should never be given to the seller, but rather be held in trust by the relevant advocate. Even after signing a sale agreement, subsequent checks and site visits are recommended.
Land can never be an emergency. It is never that deal that must be done today. Take your time.
Missing land titles, not for sale signs, prolonged idleness, and conflicting ownership are all indications of a bad land offer. Patrick Igunza, Property Insight.